I'm Angela Onwuachi-Willig. I'm the Dean of Boston University's School of Law, and I want to welcome everyone to our annual Max M. Shapiro Lecture. Max Shapiro graduated from BU Law in 1933 and embarked on a successful 60-year career as a trial lawyer. In addition to his remarkable dedication to each and every case he tried, Max embraced the role of mentor, inspiring younger attorneys through the strength of his character. Shapiro Lecture serves as a fitting tribute to the memory of a lawyer who was devoted to advancing the cause of legal ethics and trial advocacy. So we are grateful to Max's son, Andrew, his daughter, Sue Ellen, and Sue Ellen's husband, Larry, for funding this endowed lecture to honor his legacy. Members of Max's family have remotely joined us for this lecture, and I want to extend a big warm welcome to all of them. And a big thank you from our BU Law community. So welcome and thank you. This year's lecture features a truly phenomenal panel, a discussion between three outstanding jurists, the Honorable Nancy Gertner, the Honorable Jack McConnell, and our very first official jurist in residence, the Honorable Robert W. Pratt. BU Law Associate Professor Zohra Ahmed, who's a brilliant scholar and teacher, as I know many of you know, will moderate this distinguished panel. But first, I want to share a little bit about each of our panel members. Chief Judge Jack J. McConnell Jr. is the Chief Judge of the United States District Court for the District of Rhode Island. President Barack Obama nominated him for appointment to the court in 2009, and the United States Senate confirmed his nomination in 2011. A graduate of Brown University and Case Western Reserve. I'm gonna put my page. Yes. We don't have a podium, so it's kind of hard to do this. And Case Western Reserve University, Chief Judge McConnell came to the bench after a remarkable career as a litigator. Former partner and director of the Environmental Practice Group at Motley Rice, LLC, he played a critical role in investigating and litigating claims in a multi-state lawsuit against the tobacco industry. Ultimately, he helped to draft a $264 billion and 46-state settlement between the four largest United States tobacco companies and attorney generals of 46 states in relation to the state's Medicaid lawsuits against the tobacco industry for recovering tobacco related health care costs. As one part of the settlement, the four companies agreed to curtail and cease certain harmful tobacco marketing practices. And importantly, they agreed to pay in perpetuity various annual payments to the states to compensate them for some of the medical costs they incur in caring for people with smoking related illnesses. In addition to his administrative duties as the leader of the U.S. District Court for the District of Rhode Island, Chief Judge McConnell hears a full docket of both civil and criminal cases. He also served for 6 years as a member of the Committee on the Codes of Conduct of the Judicial Conference of the United States. He's also found time to engage in important community work, particularly helping the unhoused. For 11 years, from 2011 to 2022, Chief Judge McConnell served as board chair for Crossroads, Rhode Island, the state's largest service agency for the unhoused. And it was work that he eloquently described in a Boston Globe interview, and he described as really reshaping his thoughts. And I wanted to share some of his thoughts because I think they're really, really amazing. He said, when I first joined the Crossroads board, I thought our job was to make people experiencing homelessness comfortable, keep them fed, keep them warm, and make sure they aren't sleeping on the sidewalk. It's still important that we provide people with safe shelter, especially when they are in crisis. But looking back, I now see that I viewed the work through a very narrow lens. Over the past decade, I've learned so much about the root causes of homelessness, and I've developed a deep belief that the only proven solution to homelessness is housing, and that when we get folks into housing first, we can much more effectively support the rest of their needs, whether it's substance use disorder, unemployment, or any of the other contributing factors that often lead to homelessness. He continued, we need to stop dealing with issues of homelessness and addiction and other societal programs through the criminal justice system. Housing really is a foundational need. If we can connect housing with healthcare and connect housing with education, more people will have stability. But when people are housing insecure, they are more likely to find themselves involved in the criminal justice system. I see people in my courtroom far too often who would be much, much better served in the social services system than the criminal justice system. I want to give you a sense of each of our speakers, and we're really delighted to welcome Chief Judge Jack McConnell. Yes. Woo! Um, the Honorable Nancy Gertner is a retired jurist from the U.S. District Court for the District of Massachusetts. For her entire career, Judge Gertner was a fierce advocate for women's rights, racial equity, and civil rights overall. As a new attorney and only one of a handful of women practicing law and serving as a trial lawyer during the 1970s, she made her mark by not only, and I'll say this, making us all wonderfully proud by wearing beautiful BU red suits and a sea of black and blue suits, but by also courageously taking on prominent, controversial, and highly complex criminal defense and discrimination cases. One of her very first cases involved defending anti-war activist Susan Sachs, who was on trial for her role in a robbery that tragically resulted in the death of a police officer. And she successfully brought other groundbreaking cases, like a sex discrimination lawsuit by Teresa Cortado, the very first woman stockbroker in New England, against Merrill Lynch, and the tenure sex discrimination lawsuit by Professor Claire Dalton against Harvard Law School, where Dalton ultimately was awarded tenure. As a jurist, Judge Gertner was equally fearless. She was appointed to the bench by President Bill Clinton in 1994. And to give you one example of this fearlessness, in 1998, in United States versus Leviner, Judge Gertner departed downward from the sentencing guidelines range on the grounds of the African-American defendant's record, which was overwhelmingly motor vehicle violations and minor drug possession offenses, overstated his culpability and the likelihood of his recidivism. In describing how the defendant's criminal history score mirrored disparities in state sentencing and, in particular, racial disparities, Judge Gertner wrote, motor vehicle offenses in particular raise deep concerns about racial disparity. Studies from a number of scholars and articles in the popular literature have focused on the fact that African-American motorists are stopped and prosecuted for traffic stops more than any other citizens. And if that is so, then it is not unreasonable to believe that African-Americans would also be imprisoned at a higher rate for these offenses as well. Leviner's motor vehicle offenses were mainly for driving while his license was suspended, except for one use without authority. Not one charge involved driving erratically or violating a traffic law. The distinction is important. While I could make no judgment about what happened with Leviner's motor vehicle charges, surely the studies described above raise questions about what drew the officer's attention to Leviner in the first place. Moreover, these stops evolved into countable offenses under the guidelines only because they were offenses for which he received more than 30 days imprisonment. Again, without knowing the facts surrounding each sentence, this record raises concerns at the very least. Would others have received the same sentence who were similarly situated, no matter how often they had been apprehended driving after their license had been suspended? So Judge Gertner is a graduate of Barnard College and has a master's and a JD from the Yale University. Judge Gertner has brought that same fierceness and passion for justice to the legal academy. An outspoken critic of the U.S. sentencing guidelines, Judge Gertner has taught sentencing and comparative sentencing at her alma mater, Yale Law School. In September of 2011, she retired from the bench and joined the faculty at Harvard Law School, where she continues to teach a number of subjects, including criminal law, criminal procedure, gender context and judging, and forensic science and sentencing. She's published widely on topics ranging from sentencing to workplace discrimination to the jury system. Her autobiography, which is fantastic, you should read it, In Defense of Women, Memoirs of an Unrepentant Advocate, was published in 2011. And her article, Loser's Rules in the Yale Law Journal, is really a must read for anyone who is looking to practice employment discrimination law. Judge Gertner has received numerous awards, too many to name, but I'll name just a few. The Martin A. Brody Distinguished Judicial Service Award, the American Bar Association Margaret Brent Women's Lawyers of Achievement Award, the Lilia Robinson Award from the Women's Bar Association. Wanted to sneak that in because she's a BU law grad, the very first woman admitted to the bar in Massachusetts, and she's the one who wrote the legislation to allow that to happen. And the Thurgood Marshall Award from the American Bar Association, for which Judge Gertner was the second woman to receive that award only after Justice Ruth Bader Ginsburg. And of course, a number of women, more women have now received that award. So we're delighted to welcome Judge Gertner to BU Law. Our moderator, Professor Zohra Ahmed, writes and teaches about the US carceral state and US militarism. She's particularly interested in the interactions between law and political economy and law and social movements in these two domains. Professor Ahmed started her career as a public defender at the Legal Aid Society in New York City, where she also founded a community court watching project. She entered the academy in 2018 as a clinical teaching fellow at Cornell Law School. And in 2021, she joined the faculty at the University of Georgia School of Law. And of course, in 2023, the most important year, she joined our wonderful faculty at BU Law. And she's continued to excel as a teacher and as a scholar with articles in leading law journals like the Columbia Law Review, the UCLA Law Review, Michigan Law Review, and the Yale Journal of International Law, to name a few. I have one more thing to brag about Professor Ahmed. She serves as the advisor to the Community Justice Exchange, the home of the National Bail Fund Network, where she supports grassroots social movements challenging criminalization. Last but not least is our first official jurist in residence, Judge Robert W. Pratt. He is a retired senior judge from the United States District Court for the Southern District of Iowa. He was nominated to the bench by President Bill Clinton in 1997. He's an avid runner, and he very aptly served 26 years and 2 months on the federal bench. He served as chief judge from 2006 to 2011. He assumed senior status in 2012 and transitioned to an inactive status just last year. He's a graduate of Loras College in Dubuque, Iowa, and Creighton University School of Law in Omaha, Nebraska. And after he graduated from law school, he began his professional career at Polk County Legal Aid Society. So now President Biden has appointed a lot of people who do public services law, but he was really one of the few who came straight out of Legal Aid Society and then made it to the federal bench. He represented low-income clients in a variety of cases: domestic relations, consumer law, landlord-tenant. He moved to private practice and represented people in organized labor and also criminal defense. He opened his own firm, which he ran with great success until 1997, and he is a fierce litigator. He argued 24 cases before the United States Court of Appeals for the Eighth Circuit, as well as 20 cases before the Iowa Supreme Court and Iowa Court of Appeals, and of course has litigated and tried many, many cases to verdict, dozens of cases to verdict. As a U.S. District Court judge, he presided over 150 cases that went to verdict. He also served as appellate judge on a number of panels, the Eighth Circuit, the Ninth Circuit, and importantly, I'll say that twice he was asked to testify before the United States Sentencing Commission. And he was asked to do this precisely because of his just approach to judging and sentencing. He's built a reputation for his thoughtful, principled, and courageous approach to the law. As the Iowa State Bar Association website notes, he admirably never feared reversal and simply focused on, quote, getting the law right, end quote. He's presided over cases that shaped and reinforced important rights and liberties, and of course, no case illustrates that more than Gall versus the United States, where the United States Supreme Court upheld his variance from the sentencing range in the US sentencing guidelines, making it clear that there was no rule requiring proof of extraordinary circumstances to justify a sentence outside of the guidelines range, and making it clear that the appropriate standard of review for the appellate courts was an abuse of discretion standard. I want to note that after Booker, which was the decision that held that the U.S. sentencing guidelines were advisory, not mandatory, Judge Pratt followed Booker, but was reversed 7 times before the U.S. Supreme Court took up the issue in the Gall case and ultimately made it clear that Judge Pratt had all along gotten the law right. And speaking about the Gall case, Senator Charm Harkin said, the Gall case gave judges the power to weigh different factors in determining fair and just sentences as opposed to some mechanical formula. In other words, judges should judge. It has been our great pleasure and honor to have Judge Pratt join us for these past 2 weeks. He shared with us the wisdom gained from many of his years of experience on the bench, and as a trial attorney, he provided his expert insight on current judicial issues, and he's offered mentorship and guidance to our students, to our faculty, and to our staff. It's been an honor to have him here over the past 2 weeks. I want to say that welcome again to this panel, Judge Pratt, and thank you all for joining us for the Max Shapiro Lecture.
All right, well, I'm delighted to be here, and without further ado, let's get to our questions. I'm hoping that we can reserve 10 to 15 minutes at the end for your questions as well. So, as federal judges, I know that sentencing is likely the hardest part of your job, one of many hard parts, but certainly one that has very significant stakes. And the federal sentencing guidelines have imposed some constraints on these already difficult decisions. If you could share with us your views about the sentencing guidelines, whether they're just, and what role you've played to make them more just. And then finally, would love to hear your thoughts on what are the next frontiers of reform for sentencing in federal court. We'll start with you. All right. Please, Judge Gertner.
Do you hear me now? Okay. I like it that Judge McConnell just starting with the most senior. This is not a good thing to say. I just want to make this clear. You know, so I was a judge at a time when I began in 1994, and the sentencing system literally, in my view, went off the rails. I came on board in 1994 after the passage of the first death penalty, federal death penalty in a long time. The guidelines were mandatory, but not satisfied with having guidelines that would shape sentences. Congress essentially passed additional mandatory minimums. So I had been a criminal defense lawyer and a civil rights lawyer the day before I was sworn in as a judge. Imagine my surprise that I could essentially do next to nothing, it appeared initially, with the guidelines. I was teaching at Yale at the time, so that I could figure out how to criticize these guidelines. I mean, I had to follow them, but they made absolutely no sense. Let me give you an example. There are 2 examples I think about. One is addiction, the guidelines said, is not ordinarily relevant. Addiction is not ordinarily relevant to sentencing. In fact, substance abuse disorder pretty much characterized something like 80% of the men and women that I sentenced. And yet it was not relevant because it was a longer discussion. This is what I teach, essentially, a reaction from decades ago when addiction was seen as a choice. You chose to be addicted. Never mind that by the time you've been addicted for 20 years, there's no meaningful choice. So addiction was not ordinarily relevant. And that was because essentially Congress didn't want judges to exercise judgment, right? If you had to exercise judgment, you didn't have to exercise judgment when you were computing someone's criminal history. That was a formula. You didn't have to exercise judgment when that person was in a particular sentencing box. But if we added addiction to the measure, judges would have to exercise judgment, which it seemed to me was precisely what I was supposed to do. The other story I talk about is family circumstances had to be extraordinary, not because the guidelines were defining what most cases would be, and so if you wanted to depart from the formula, you had to make it had to be clear that it was extraordinary. What was an extraordinary family? Was it race-based? right? Because the families I was seeing didn't look like, as I wrote in one opinion, Ozzie and Harriet. What was an extraordinary family circumstance? Women who were typically single mothers who had come to my court. Of course, there was nothing extraordinary about them, except being a single mother mattered. So in the interest of eliminating sentencing disparity, which is what triggered the guidelines went all the way over to essentially treating people like boxes. And I rebelled against that from the very beginning, trying to critique the guidelines, trying to understand, not ignoring them, right? I was a judge, I swore to uphold the law, but trying to understand where there was room to critique and room for discretion. And your dean talked about one case where Alexander Leviner was a felon in possession of a firearm case. The guideline computation of his criminal record was very high. And it was very high because he had been stopped a number of times in the white suburbs of Boston for driving after his license was suspended. And all I was supposed to do was to look at the amount of time he was sentenced in each of those cases, 30 days, 60 days, and 90 days, which was itself shocking for driving after your license was suspended. And the net effect of those sentences meant that he had a criminal record, a computation again, that was high, relatively high. The lawyers didn't argue the racial implications of this. The lawyers were making their usual arguments. I looked at this and said, this is preposterous, and it was important for judges to name it. It wasn't enough just that I would vary, in those days depart, but I wanted to name it because I wanted to have other judges be as critical of the guidelines as I was. Make a long story short, this is what I teach and what I write about. From 1994, when I went on the bench, to 2005, the guidelines were mandatory. I was reversed numbers of times for trying to come up with critical commentary on the guidelines. It didn't bother me that I was reversed, except I was right and they were wrong. I mean, and the advantage is that I'm writing about judging and sentencing now, and I'm going to get the last word. From 2005 to 2011, when I left, the guidelines were advisory, but calling them advisory is ignoring the elephant in the room. In some parts of the country, that is a meaningless word. In other parts of the country, even when judges are not, and you two can speak more specifically, in many parts of the country, they still drive sentences higher than they otherwise should be. Let me make one final comment, because as I said, I can go on about this. So we are now stuck with a system, advisory or not, that was promulgated in 1985 when crime was rising, before we understood the racial implications of much of the decisions we were making, before we understood the impact of neuroscience on what we know about addiction, what we know about trauma, what we know about adverse childhood experiences, and yet they still have an impact on sentencing. Now that should be an outrage to everyone in this room, and the advantage of being fully retired, as Bob will learn, I can say anything. My husband likes to say that I've never met a microphone I didn't like.
Professor, you've hit on something, and Nancy has expanded it, which I think is sometimes overlooked, that we are still in the era of mandatory sentencing because of what Nancy added to Professor Ahmed's question, and that is we have mandatory minimum sentences that also control to this day, and that haven't been repealed, even though they should. And so I came to the district court in 1997. I had not tried a case to verdict in federal court. I only tried 3 cases to federal court in criminal cases in my life. And I hadn't tried one for 12 years. My practice had morphed into more of a legal aid kind of practice. So when I came to the district court, and I'm going to ask the question because my background and the background of Nancy and Jack play a huge part in our work. And so when I came, the first day I was there, the magistrates who usually do initial appearance, they were on vacation. I'm doing initial appearances. They're reading an indictment out loud, and the U.S. attorney says, and there's a burden that you have to detain the defendant because we indicted claiming he committed X crime. And I said, oh, I know all about the presumption of innocence. You don't have to tell me. No, Judge. So in all this time I had been away, the statutes Nancy was talking about and the commission had been created. So I had a big learning curve. And I was helped because one of Nancy's colleagues at Yale, Kate Stith, and her husband, Jose Cabranes on the Second Circuit, wrote this book called Fear of Judging. And it was all about this idea of cabining, reining in judges was the biggest thing that had happened to American law since the founding of the Republic. And then I stumbled across an article. I'm very close to Roger Williams Law School, and it's called The Racial Antecedents of the Guidelines from Booker to Brown. And the guidelines were, and to some extent still are, an attack on judges. The same complaints that the Southern Manifesto and members of Congress made about judges are the very same complaints that they made about judges that led to the guidelines. It's the same playbook. Judges were coddling criminals. Well, it wasn't true. Guidelines were needed to control Black people. Judges were using sociology to sentence defendants, expert testimony. Well, in Brown, Chief Justice Warren talked about the white dolls and the black dolls, and Dr. Kenneth Clark's testimony in the record. And so I realized that this was all about judges, and that so when this evolution and revolution happened, we judges, I think the law is made with lawyers and the academy. And so you people, law professors and ingenious lawyers like Nancy Gertner, came up with this theory that the guidelines were unconstitutional because you were depriving people of the right to a trial by jury. And in doing the declaration of being unconstitutional, you restored the trial judge to its historical role of having discretion. So until we get over these racial antecedents that continue to drive our system, I don't think we're going to make progress. We need to use sociology. We need to use expert testimony. The idea, to the good part of the guidelines, it's supposed to be a dynamic and ever-changing situation, and there are some good things that come out of the guidelines. I'm going to give one specific example. One of the big problems in a rural white federal district like I am in is I'm in Southern District, contains Polk County, which is the largest county in Iowa. And the U.S. attorney and the local prosecutor, their primary witnesses are Des Moines police officers. So when the Des Moines police officers abuse suspects and when they don't act reasonably, it doesn't get prosecuted. So lo and behold, I had a case against a Des Moines police officer accused of excessive force, 18 U.S.C. 242. It's an old law that has been revived. It's called Screws versus the United States is the name of the case. And so we go to trial, and the jury, the defendant has an expert, jury hangs, and to the U.S. attorney's credit, it did not, they didn't dismiss. And so Maine Justice sends out to my court for the second trial one of the best lawyers I've ever had. She was about 5'2", Barbara Bernstein. She was the assistant chief in the Civil Rights Division, the criminal division. She'd tried the police in Katrina, and she secured a conviction. And so now comes sentencing. What should I do? And here's the good part of the sentencing guidelines that relies on sociology and research and helping judges get the right answer. I called the Sentencing Commission. I said, I've never had an excessive force case. There's very few excessive force cases. And Nancy Gertner was the first judge that urged that you district judges should write opinions, because we can't make a common law of sentencing that will let our colleagues see what you've done and develop the common law just the way we're supposed to. So when Angela mentioned the Gall case that I had, Nancy and I were in the same committee. And she said, you got facts like that, you got to write an opinion. So, I've had more than one appellate person tell me, the reason that outcome, it helped the outcome, was that you weren't just on a record rambling and you have a colloquy between the lawyers and you figure out what's going on. So I think we have to do that. But when it came to this case, I had the Sentencing Commission tell me, well, first of all, across the country, when you look at statistics about excessive force cases, most of the cases go out by plea, like we know already happens. But when they do go to verdict, or when they police, cops get these incredible breaks because they know, the U.S. attorney who's prosecuting, know that they're going to have to rely on this very same police officer. So that's kind of a nuance to me, that the sentencing guidelines and being able to develop expertise in we are now sentencing the quote unquote criminal, the accused, the convict. We used to sentence the crime under the mandatory sentence. Everybody was the same. And now we can actually apply the parsimony division of the sentencing statute that says one must give a sentence that is sufficient but not greater than necessary. The rule from Montesquieu and these other people that brought us the rehabilitation model was that to the extent you deprived a person of one extra day of liberty, you were violating the due process clause. And so I think that we have much better system than we have. I think judge-made law has made a huge difference. The Sentencing Commission now has a very dynamic leader, Carlton Reeves, who I know, and very new members, John Gleason, one of Nancy and Jack Guy's former colleagues, that brings his experience to bear. So I think from a research and dynamic and ever-changing way, to get to the professor's question, we can make a better sentencing system, but it's going to take well-funded research and sociology and all the things that we know that helps the law grow.
Do you have a working microphone?
Is that working? Is it working now? There's someone in the back that's giving us the... a few things. Let me join the Dean specifically in thanking the Shapiro family for sponsoring this lecture. More and more and more in today's society, the ability to have civil discourse about difficult issues, particularly at universities, which should be the bastion of bringing this about, is just so important. So I thank them for their commitment to that. It was important that I go third because the truth is Nancy and Bob are my idols. They've been my idols. They've been my mentors. Bob called me up before I even became a judge. I knew his son and gave me sage guidance. I read Nancy's book In Defense of Women. Particularly any woman that wants to go into litigation, but anyone that wants to go into litigation at all should read the book. It's more novel-like. She tells stories in it. It's just, it's an outstanding book about what it's like to be particularly a woman, but to be a litigator in the criminal justice world. So In Defense of Women should be on everyone's list. She knows I keep 4 or 5 copies in my chambers, and whenever I encounter somebody, I give them the book and tell them to read it. So I think that's really important. Let me also add, we need to remember that what we're talking about here is the federal system. the vast majority of problems and the vast majority of touches in the criminal justice system occur in the state courts. We're a minor part. So we talk a lot academically and whatnot about the guidelines and the effect, but for those that want to dwell in criminal justice and have the greatest impact, the truth is we are a very small part, and there are equally as unthoughtful procedures and outcomes in the state court. It's just magnified massively. So let me just put that caveat on it, because we are in a small little world. You can't talk about criminal justice reform without looking at our criminal justice system. Perhaps you've all heard this before, but I think it bears repeating. The United States incarcerates 25% of the world's incarcerated folks, yet we are 5% of the world's population. We over-incarcerate more than any other country. On numbers alone, we have more people in jail than any other country, second only to China. And yet we're the land of the free. Now, perhaps you might say, well, we have more crime, so we need this. There is zero relation. In fact, there is an opposite relation between incarceration and crime, or actually probably a parallel one. It appears the more we incarcerate, the greater the crime rate, right? One would assume that if you put people in jail to rehabilitate, to lower crime for criminal reasons, that as the more people we put in, the lower the crime rate would go. Well, since 1970 and the war on drugs brought about by President Nixon et al., all the way through, and it's a nonpartisan problem. It's, you know, Bill Clinton's 3 strikes you're out and whatnot. It's not a partisan issue in that regard. Ever since then, our incarcerated folks have gone out of control, and the vast majority of those come from communities of color. We know, percentage-wise, communities of color are not performing more criminal acts. We know, for instance, statistics tell us, on just marijuana alone, when it used to be criminal, that whites smoked marijuana far more than African Americans did, yet we incarcerate more African Americans for smoking marijuana. The system is broken, and that sounds like a cliche, but it is so personal, particularly to communities of color, because of the effect it has on it. We have allowed the criminal justice system to be the way, in my opinion, that society deals with racism, with mental health issues, with substance abuse issues, with poverty. I could go on and on of society's evils that we don't want to deal with, and we default them into the criminal justice system, and then we say to judges at sentencing, you deal with it. You deal with the young African American that can't get an education, doesn't get a job because the school system's not preparing to it, and therefore turns to drug dealing as a profession. You deal with that, which is based on poverty or based on racism, but we're not going to give you the tools, right, to actually get at the root problem. So we're hampered in the criminal justice system. Now, I don't believe we should abolish the criminal justice system. There's a role for it. And if you actually look at the federal statute that tells us why do we sentence people, we sentence people for, correct me if I'm wrong, but 5 or 6 reasons Congress tells us. And you're supposed to consider all of them, not a single one of them. We sentence people to punish them. We sentence people to deter them so that they don't do it again, don't recidivate. We sentence people to deter the general public, right, to serve as an example. We sentence people to show respect for the law. We have laws, you must follow it, if not there's consequences. And we sentence people in order to assist in rehabilitation. And then the statute tells us, and I think many times judges forget this, that you're to impose a sentence that does all that, but is sufficient, but not more than necessary to do it. And what I have found in my observation, the sentencing guidelines and how judges act is we don't actually drill down and think about the issues that Congress tells us we have to. For instance, punishment as an element of committing a crime. Most of us, and most of you probably, and most of society thinks that the time of incarceration is an element of how much the person is being punished. I am of the belief that in many, if not most instances, you don't need incarceration to factor in the punishment element that statute requires us. There's a study that recently came out that shows that there are 44,000 negative reasons in our statutes and in our regulations that punish a person convicted of a felony without ever sending them to jail for a day. Now, that's an outrage, and we should do something about it because people should be rehabilitated and it shouldn't be burdened. But when somebody pleads guilty, is found guilty of a crime, 44,000 different negative aspects, 44,000 punishments go with that. And you can all think of what they are, right? You might lose your right to vote in some states. You might lose the ability to get certain government jobs. You lose certain Section 8 housing issues. And we could go on and on and on about it. So I think one of the fundamental problems with the sentencing guidelines is that I call it, or in my courthouse with my fellow judges, we tend to think a lot alike about criminal justice in Rhode Island. We have a toolbox when we sentence. You look down and what's in my toolbox that can punish, deter, rehabilitate, show respect for the law. And the only thing that's in there is incarceration. And that's fundamentally what has to change if we're going to change the criminal justice system. We put too many people in jail and we put them in for too long. I'll bring up one unofficial, unscientific instance, but I think if it were calculated out, it would be true. In Rhode Island, we have the distinction of being the federal district in the country that sentences below the guideline at a greater percentage than any other district in the country. Don't applaud that. Applaud the next fact. Well, you can applaud that. That's fine. 77% of the time, we sentence below the guideline range. Okay? So here's what you should applaud. What's our recidivism? We're sending people to jail less, dramatically less. What's our recidivism rate? Much, much lower than the national average. That you should applaud. Because we're too small to actually be a study. And so I'm trying to figure out how we can look at this nationwide so that it's part of it. But there is no correlation at all. None. Zero. In fact, there's an opposite correlation. New studies are showing us between putting people in jail and them not committing another crime. It doesn't exist. It's a knee-jerk societal reaction as opposed to scientific-based, data-based, thoughtful, real reaction. And to me, that's the major problem with our criminal justice system.
Zohra, can I have the mic for a minute? To tell you that these aren't just the judge's views, this is some empirical evidence. You all believe the same thing Judge McConnell just so well articulated. Four of us, 2 judges from Northern Ohio, this is a result of the IT committee that Nancy and I were on. 2 judges from Northern Ohio, colleagues of ours, and a judge from Northern Illinois, and myself conducted this experiment, and it involved people like you, jurors. So the jury has come back, returned a verdict, and myself and my law clerk go into the jury room and we say, not here to talk about the case. Here's what I'm here to tell you. I now have the responsibility, because you have decided that this person is guilty, that I have the responsibility for sentencing this defendant. So I've asked my probation officer to give to my law clerk his criminal history, because that's one factor when you go down part of the guideline that I must consider into the law. And you've determined what's called the offense conduct, which is the other factor that I have to take in when I arrive at the advisory guideline. And so after you have this form that I give you, I want you to tell me in the number of months what you think a sentence should be. we had 16 verdicts from Southern Iowa, Northern Illinois, and Northern Ohio. Jim Gwynn, a colleague of Nancy and I's on the Northern District of Ohio, wrote an article that's published in the Harvard Law of Journal of Law and Policy. And the bottom line is, so this is the article is entitled Juror Sentiment About Sentencing. And I'm gonna, Professor Ahmed has probably this down, but I believe the number is that the median sentence of all of those verdicts, there were 16 of them, was that it was 35% of what the lowest guideline was. So jurors know that we have a harsh system. The public knows that we have a harsh system. What Judge McConnell said was that our system operates on disinformation and misinformation because people get votes by appealing to misinformation and disinformation. So I just wanted to get that in, that you all out there agree with us. It's not that the public thinks that our system is too harsh. They think the opposite. So, yeah.
I just you'll never get a word in edgewise. I just want to make this clear. I have come in my writing to talk about this as the habits of mass incarceration. That even when the guidelines became advisory, that there were judges who still framed what they thought the fair sentence was based on those decades of mandatory guidelines. And what we see today, right this minute, crime is declining everywhere. The guidelines originated when there was a crime spike and moral hysteria about it. But now crime has declined everywhere, and it doesn't matter. It doesn't. The conversation among politicians continues to be tough on crime and carnage in our streets. And that I actually, in my 9 million years on this planet, have never seen before. Because one would have imagined that criminal justice issues, laws, punishments would at least dovetail with the crime rate, which had been the case. You know, as I said, the guidelines started and mandatory minimum started when there had been a crime spike. But it doesn't seem to matter because the habits of mass incarceration die hard. We have simply framed the way we respond to crime in that way.
Thank you. So we've heard a little bit about the sort of quiet, silent, and very strategic organizing, I think we could call it, that happened on the IT committee to resist the sentencing guidelines. And so that's about pushing back and educating the legislator. I'm wondering about the prosecutors, because obviously they play a really critical role in steering the direction of criminal court. And just to sort of share with all of you, over half of all criminal cases in federal court are drug cases and immigration cases. And so those are not the typical criminal cases that you learn about in 1L criminal law. And so in some circumstances, people might consider the drug cases public health issues, and immigration cases mostly a question about, immigration rather than criminal activity. But ultimately, these charging decisions are ones left for the prosecutors. So I guess I'm wondering, what role can the judiciary play in drawing attention to these charging decisions, pushing back, and educating the public about these charging decisions?
I'm the only one subject to the judges' codes of conduct on this. I just want you to know that. That's why they like to push it to me. I'll represent you. Yeah, thanks. What role do judges have to play? So the role of a district judge is one individual, one at a time, individual justice in the moment, right? So I think one of the things is having conversations amongst judges about the very topic that we're talking about and enlightening them. And you know, when I first began, she probably doesn't remember this, but I saw Nancy at a conference 13 odd years ago, and she's the one that posited in me the beginnings thinking about looking at this in a different fashion. So I think one of the most important things is to get people talking about it. And then I'm going to go back to the issue of so much of what we do in the criminal justice system is not based on reality. It's not based on facts, and it's not based on data. And we knee jerk. And that knee jerk, which can oftentimes be meaningless, is hugely important in our communities, and particularly in our communities of color, which are over-policed, over-prosecuted, and over-incarcerated. So I think one of the things is getting the powers to be to look at facts and statistics, and I think we now have a sentencing guideline, a sentencing commission run by Carlton Reeves, who is one of the finest human beings and judges from Mississippi that we know of. If you ever want to read just an outstanding opinion, Carlton Reeves wrote about qualified immunity out of Mississippi, and it's a devastating story about racism, criminal justice system, and whatnot, and it's so well written. He now chairs the sentencing commission. So I'm going to say I'm willing to not answer that question and give the sentencing commission a chance to lead us in that regard, because I think they can, and I think they will.
The answer is that there is not a great, you were asking specifically about prosecutors. Yeah, and there's not much one can do except exercise moral suasion. You know, I'm writing a book about sentencing, and one of the people that Jack has heard this story before. One of the cases that made me start writing this book was a guy who was charged with a minor drug crime as part of a larger group, and he had a bullet in his brain. He had been shot. They couldn't get the bullet out. And trauma was nowhere mentioned by anyone in the sentencing presentation at all. The notion of the experience of that. The guidelines were at 4 years, which was already, in my view, too much. The government wanted 11. And I literally said to the U.S. attorney in my courtroom, I said, "You can't be serious." And the most that I could do was to say to him, "Why are you doing this?" And his answer, which was very telling to me, was he said, "Well, we happen to know that Damien is an impact player." And I said, "If you know that, you prove it." He says, "Well, there's word on the street." I said, "I don't do word on the street in my courtroom. I do facts." But all I could do was to question what he was doing and call it out. And part of what I would do in decisions is call it out. But other than that, we've now put a great deal of hope on progressive prosecutors on the state side, who are getting unbelievable pushback from the political system. Unbelievable pushback from the political system, which suggests that while progressive prosecutors can be important, the system, the kind of change that we need to talk about has to go deeper than that, because they can't do it alone. But that was the most frustrating thing as a judge. I would watch, as a judge, the mandatory minimum that would be charged. And there's a wonderful decision that Judge Gleason once wrote in a mandatory minimum case. He imposed the mandatory minimum because he has to, and then he did a narrative of why it made absolutely no sense, and ended with a line that says, "There's no judging going on here. Make no mistake about it. The prosecutor has sentenced." And that's the only way to deal with this, is to sort of flesh out what those decisions have meant. But other than that, it was just moral suasion and jumping up and down and writing this book, which is going to be so good.
Oops, one thing that comes to mind is when the Court of Appeals wants to turn us, am I on? When they want to reverse us, the Court of Appeals, they make up the facts. They're supposed to be bound by clearly erroneous, or they say we abused our discretion. Well, the reality of federal criminal justice, and I think state, is that all the discretion lies with the prosecutor, as these two have said. I don't know how you tell the U.S. Attorney you can't do that. And we had one of the last Kennedy appointees was in my sister district, Nick Edward McManus. He lost for governor in '60, and JFK made him a U.S. District Court judge. And this is kind of the ultimate about why the district judge has very little to do with the continuing prosecution of crimes that should not be prosecuted. And that's why all the people that I know that are now judges that have been U.S. attorneys tell me it was the greatest job in the world. Ray Deary in Eastern New York, Jim Rosenbaum in Minnesota. And so what U.S. attorneys, in my view, should be doing is this over-federalization of street crime that we've done. And this is something that the Federalists agree with us about. There's a prof at LSU that, and Ed Meese of all people, in the mid-'80s, they did a study about how all this has been dumped into federal court unnecessarily. What U.S. attorneys should be doing is white-collar crime, political corruption, and they have the resources to do this. So using our local police to get a drug conviction is not common sense policing or prosecution. So anyway, I want to get back to Judge McManus just briefly. There's actually still a statute that says if the postman does not deliver to you junk mail, it is a felony. So they made the mistake the government did of getting an indictment in Northern District of Iowa. And it was before Judge McManus, and he ridiculed the prosecutor and said it was a terrible, what are you doing with this? So they convict. And it gets time for sentencing, and Judge McManus fined the fellow 25 cents because he told the government it was a 2-bit prosecution. I yield.
Thank you for that story. I think, given the theme of this panel, judges' obligation to improve the law, and that most people in the audience are going to be lawyers rather than judges, would love to hear your stories about lawyers that helped you do the right thing when you were impressed by creative, innovative lawyering that helped you in your decision making.
I told the professor, she sent us these questions she was going to ask, and I realized this was the hardest one because I told her honestly, and she said I should just say this. I've not really seen very good lawyering in my 13 years on the bench, sadly. I was much more a product of state court litigation. I love practicing in state court, and I thought, I'm going to the fancy dancy federal court now, and everything's going to be elevated. Well, it just isn't. Well, it wasn't. So sadly, I've not seen a lot of it. A few. I've seen good jury work. I think occasionally. I don't think we're training people on how to be good trial lawyers before a jury. I think, the law education system is you take people that don't know anything about the law. It's the only graduate work, as Brian Stevenson teaches us this. It's the only graduate school that you can go to with absolutely no qualifications and experience is law school. Everything else, you have to take engineering, you have to take science classes to get into medical school. You don't have to take anything to get into law school, right? So we take these people, and we teach them how to think like lawyers, and then we send them out in the world, and we don't get them to think like people again. So what you find oftentimes in the courtroom is, I'm going to write a book one day, maybe, that's called about the forgotten people in the courtroom, and that's the jurors. Many, many, many trial lawyers that I see forget that the jury is the most important person in there that they need to speak to, and they talk in legalese, and they worry about what the judge is thinking of them and all. So one very creative thing, we have a pro bono panel in Rhode Island. We had a 1983 action. A guy, a pro se man brought a case. He was running through the city with a gun. Bad thing. He hid under a porch. The police found him. They made him run all over the city, so they took him out and they beat the crap out of him. And then, of course, charged him with gun things, and he's in prison, and he charges this 1983 action. We sent the case to our pro bono panel, and a corporate commercial litigator that has never stepped foot in a prison, never had done any kind of courtroom work, in his closing argument, got on all fours in front of the jury and demonstrated how it was not possible that this defendant could have swung at the police, which was their response for beating them up, because of the angle of his. And here's this guy in his three-piece lawsuit who represents banks, and he's on the floor in front of the jury, sticking up for this bad guy, right? Guy running through a city with a gun, and it was the most amazing thing I've seen, where he realized this is what the jury needs to get beyond all of the stuff, the problems that my client has, and he won a huge verdict. And by the way, got paid, because it was a 1983 action, by the other side. So take pro bono cases, because they can produce lucrative. So the creativeness, to answer the professor's question, that I saw was when lawyers realize in a trial setting that you're speaking to 6 or 12 lay people, and who are just like us, should be, and you need to bring your case to them in a way that they can understand and feel and emote and rule.
I didn't expect you to say that you also had not seen creativity in federal court, because I thought I was going to be the one grump. But no, well, first of all, getting to the notion of the guidelines, one of the things the guidelines did is squelch judicial creativity, and still does to a degree, but surely squelched lawyer creativity. I lurk on a listserv of the Criminal Justice Act lawyers in Massachusetts. I lurk because I want to react to everything I'm reading about. And they are completely stuck in the guidelines, even though the guidelines are advisory. The only questions they want to ask are the computational questions. And periodically I get online and say, that is irrelevant. Yes, do those stupid computations, but then be creative with respect to what you're proposing. Do some critical analysis of the guidelines, and I don't get any of that. So, I mean, the way that someone will one day write about the impact of this law reform, which were the sentencing guidelines, not just on judges, but on all the players, because essentially the day after the guidelines became advisory, I had a case in my court, and I think it was a violent crime case. And the lawyer said, well, now that the guidelines are advisory, we only can have to, we should diminish this, the offense conduct by 2 instead of by 1. And I said to him, why did the guy do it? Give me a narrative about how this happened. And they had simply lost the ability to do the narrative, and they still have. Let me say something generally about legal education, I might add. Because as I said, I've been teaching for almost 20 years in various capacities. And one of the problems is that you spend so long learning the legal language that you forgot how to talk English. I love to tell this story. I used to kid around with my law clerks all the time. There was a lawyer in my courtroom. I think his name was Hoover Garabedian. And I think he was functionally illiterate before he became a lawyer. And legal language was then juxtaposed on top of this, this essentially functional illiteracy. And it would come into my court and go, Judge, notwithstanding the habeas corpus, there is no corpus delicti. It was a series of, I mean, I tried not to completely dissolve on the court, but essentially it was legal language as obfuscating. And I see that with my students. You don't really understand what the case is about, but you know how to talk the talk. And then it's like, it's almost as if now we're going to have AI in the courtroom, and the AI prosecutor will talk to the AI defense lawyer and the AI judge, and no one will know what they're talking about. And so I think legal education has to talk more about narrative. And I know you know how to talk the talk, but what exactly are you speaking about? And for one, this was the only way I could learn. I don't remember case names. I remember concepts, and I remember stories. So legal education has to change, and people have to remember that the law is about stories, only about stories, from which we abstracted principles. But if all you remember are the principles and not the stories, you will know nothing.
one of the things the guideline, following up on what Nancy just said, one of the things about the guideline is eliminated jury trials. The plea rate in federal court is like 98%. And I fear, because we have colloquies, plea requirements, that after you make sufficient record, the judge can, in his or her discretion, accept the plea or not. And I live in fear, because of deal cutting and plea agreements, that people who are not guilty plead guilty. And the disappointment that Jack evidenced, I love lawyer voir dire. I love judge voir dire. I like to do voir dire. I have a PowerPoint presentation that I'm very proud of. I do jury evaluation forms. When a jury, and here's what's been eliminated, and I want to talk a moment about creative lawyering and what I think the guideline has done to eliminate advocacy in district courts, both civilly and criminal. So what happens when somebody comes into my courtroom, I tell them on PowerPoint, I said, you know, this, when you came in the court this morning, it said the U.S. District Court. It doesn't belong to me, doesn't belong to the lawyers, the litigants. This is your place. And you're going to have to come here and work. Jury service is an important part of your citizen obligation. I go through a speech about voting and taxes. I put over the PowerPoint has over the IRS building, it says taxes are your contribution to living in a civilized society. I said, well, being here and giving your best is part of your job as a citizen. And so at the end of my PowerPoint, I said, we're going to work as hard as we can. We're all co-workers here. We have different roles. You have a different role than I do. The lawyers have a different role. But I said, at the end, when you come back with your verdict, I said, there's going to be a thank you letter on your desk for your hard work. There's going to be a jury evaluation form. And there's going to be a franked envelope that will let you return this survey to me, because I want to know how we did. And so I asked them to evaluate their lawyers on opening, direct, cross, good manners, bad manners, and and I asked them to evaluate me, because the sine qua non of my judging is the last question I ask: did the judge appear to favor one side or the other? And I've given 9 years of these to an academic at the University of Nevada, and she's written an article on it. So when I begin trial, I will say to both sides, the prosecution, the defendant, how much time do you want for voir dire? Oh, 5 minutes, Judge, that's all I need. And Warren Berger tried to eliminate any lawyer voir dire. So it's now in the sound discretion of the judge. So few lawyers, in my experience, are interested in talking to the judges on their case. The judges on their case are the jurors. And here they give up before we start. So, you know, I do the best I can, but I operate on the principle, it's probably the wrong principle, that the lawyer knows more about the case than I did. They're supposed to have lived with the case day in and day out. So I'm so disappointed in my 26 years and 2 months of lawyer voir dire, except I had a double wrongful conviction case of 2 young African-American kids that were convicted in separate state trials in '77 of the murder of a just retired police chief. 26 years later, the Iowa Supreme Court found Brady violations and gave them new trials. Jerry Spence had one of the plaintiffs, and a fellow from Chicago, Steve Davis, that does these nationally, had the other one. And it was a very well-lawyered case. Part of it went to the Supreme Court. They sued both the prosecutors and the lawyers because the prosecutors went out and engaged in what I found to be investigatory acts. So long motion practice. It was argued in the Supreme Court by Paul Clement when he was just leaving DOJ. And so it came back to me after the argument in the case. They paid the plaintiffs. The prosecutors who were sued paid the plaintiffs $14 million, and the writ got dismissed. The issue was never decided. So it comes back to me. I now got the police as defendants on Brady violations. and Jerry Spence had never showed up in the case. You know, I realized that I'm talking to Gen Z here because you have no idea who Jerry Spence is, which is fine. But
Very famous lawyer.
yeah, older people know who he is. So anyway, he showed up, and I said, how long do you want for voir dire? I want an hour. I've never heard anybody ask for an hour. I said, okay. Well, earlier, I had called the chief judge in Wyoming because I didn't know if Spence was going to show up. And he told me, well, I don't know. He had trouble getting on the stage at the 10th Circuit Conference. He was like 87 years old. And he said, but call Paul Borman. He's the chief judge in Eastern Michigan. He said he just tried what was supposed to be Spence's last jury trial. And the government had indicted Jeffrey Feiger, who was Dr. Kevorkian's lawyer, for bundling money for the Edwards campaign. So I called Paul Borman, and Borman advises me. He says, well, I'll tell you this about, he says, you know, Spence has written all these books that doesn't belong, the courtroom doesn't belong to the judges, it belongs to you. So you'll make a ruling and he'll come in and pay absolutely no attention to what you ruled. But he said, I will make a prediction to you that about voir dire, he said, you know, when you're doing voir dire and the prospective juror says to you, well, I would love to serve on this case, Your Honor, but I got to stay home and take care of Grandpa. I said, yeah, I've had that a lot. And so Paul says to me, well, when the prospective juror sees that it's Spence of a certain age, she won't want to stay home and take care of Grandpa. And sure enough, so I've sent this transcript to a lot of lawyers, friends of mine and judges. I have a transcript of Jerry Spence for talking to an all-white jury for an hour about police misconduct. A guy from Wyoming trying to, you know, sensitize for his client the special qualities that you bring to a police misconduct case. So, you know, I've seen so few creative lawyers because I think voir dire, you know, I read a great book called Arc of Justice that combines about 5 things. The Great Migration, the Ku Klux Klan taking over the Department of Police in Detroit, the founding of the NAACP. Anyway, Clarence Darrow's in the case, and jury selection is a big part of the case. And Clarence Darrow said, well, once you get a jury, he says, the case has been decided. All the rest is window dressing. And so we don't have lawyers, in my view, and I'd be interested if Jack has lawyer voir dire or Nancy has, and if you see any, because I just don't see it. So anyway, that's fine.
Can we open up for questions? Is that all right? Maybe we can take a few questions, and just remember, don't snooze on voir dire. Okay, do we have any questions from the audience? And we can take a few. Yes, Kate, Jess.
I'm just curious about what your thoughts are from your experience about adolescence and late adolescence and emerging adults.
And Jess.
Yeah, my question has to do with technology in the courtroom and how you've seen it be used well and badly by lawyers.
Great, I think we can start from there. Would you like to go first?
Technology has been used badly in my courtroom. It's like you go to a speech and they put their PowerPoint up, and most of the speech is them reading their PowerPoint. I find that lawyers have used as a crutch the technology and not as a mechanism for making your argument, for advocating. So I've not actually seen it that well used. If you know, it's much better to get on all fours and demonstrate for a jury, perhaps in some fancy dancy. That's that question. The issue of youth doesn't come up as often. You have to be 18 to commit a federal crime to come before us. So we don't see it. We are seeing it now in the what's called compassionate release. Folks that are incarcerated can now apply for a reduction in sentence, whereas before they couldn't, before the First Step Act. And I have a number of cases of people that got a life without parole for a crime that they committed at 19. I wrote an opinion, United States versus Giovanni Lara. He was not the trigger man, but he was in a car when somebody was brutally shot in the back of the head. He was 18 years old. He got a life without parole sentence. He served 26 years. He applied for a reduction in sentence, and I spent months and months and months studying the issue of emerging knowledge about youthful crimes. The Supreme Court has done a decent job about, no, not such a decent job,
Right.
from below 18 for crimes committed. But what they haven't dealt with is the 18 to 26. So you can even say 18 to 21, but 18 to 26, where particularly the male mind is continuing to grow. And so I wrote in this opinion all about how culpability, we've got to look at where a person's brain is at the time to measure their culpability of a particular crime. And for a 18-year-old that wasn't the trigger person, who'd done 26 years with pretty good behavior, that was sufficient but not more than necessary. Released him. I was telling them before, he writes to me pretty regularly. He sends me pictures with his mom. He's doing great. He moved to Florida. And I think it's an issue that you'll see more in the state courts, but I do think the way that youth, but particularly the 18 to 26-year-olds, are treated, where we ignore their undeveloped, changing brain when we evaluate culpability, is a huge problem.
Just add something about on both issues. The technology, one of the things that we told lawyers, and with any trial lawyer would tell you, is not to read your opening and closing statement, right? I mean, because you come out with a formula, and in fact, the trial didn't go that way, and you absolutely can't get off track. The technology does the same thing. You come with a PowerPoint, and you stop listening to the trial. Because you had it in a PowerPoint, you're unable to be flexible. So I take what Jack is saying, that's been problematic. On the other hand, as jurors get younger, they're used to seeing things through screens. I can't teach without having a PowerPoint, much as I loathe it, because essentially the students that's the way you learn. With respect to adolescents, yes, the Supreme Court has done with Miller versus Florida, I think it was certainly the Miller case, where the court was beginning to, had recognized that life without parole, mandatory life without parole, would be wrong for people who had committed the crime when they were adolescents. But the Supreme Court backed off of that in the Jones decision. So I think there's no place to go any further. We do deal with 18 to 27. The vast majority of the men I sentenced, who I'm writing about now, of drug crimes were in that group. The sentencing guidelines at one point, which another hysterical part of the sentencing guidelines, age is not ordinarily relevant. That was great. Age was not, and then they changed the guideline to say you can consider age to the extent that there's more, that it's something like there was more of it in the case. I mean, it was an incoherent concept, but it seems to me that the court's going to have to come to grips with that age group. The adolescent issues also play into criminal records because another of the men I'm writing about started dealing drugs at 14 for school supplies. And by the time he came into my court at 21, he had a record as long as the wall. And it was a record produced in a chaotic period in his life when he was an adolescent. And at the very least, we can discount some of that, knowing what we know about adolescence. So it needs to figure in, but the federal courts, partly because they haven't been used to dealing with this age group at all, and also because, as I said before, the habits of mass incarceration, the habits of the guideline framework keep everyone from digging into these issues as they should.
This will appear that I'm tooting my own horn. However, in Gaul, I had a 23-year-old young man. And this shows you how you bring to anything, but particularly judging or jury service, your experiences. My youngest had graduated from college in '04. In '05, yeah, in '05, my bride over there is giving me help. In '05, um, his friend got killed on a Milwaukee freeway. He wasn't buckled. I'm reading the Washington Post one day, and they say there's an NIH study. The more kids that are in a car, numbers, the more likely there's going to be a fatality, and it's an NIH study about brain maturity. So when I have the Gall case and these wonderful facts about withdrawing from a conspiracy, this all comes to me. This is more about common law sentencing. I heard the testimony in Gall on May 27th. And normally the judgment is entered the day that you're there. You fill out the statement of reasons and the judgment. I took Memorial Day weekend and I wrote an opinion setting out all of the facts, and I referred in a footnote, I don't like footnotes generally, to the NIH study because it was so important to me. Well, the disappointment to me, well, then about that term, the Supreme Court in a Missouri case came along and said that it was a brain maturity case. Nancy mentioned it. I can't think of the name of it. At any rate, my disappointment going forward was that didn't get any play from the Court of Appeals or the Supreme Court, what I said about brain maturity in the opinion. But I made the mistake of listening to the appellate argument. And we had a very conservative member of the Eighth Circuit, Pascal Bowman, who was a Jesse Helms. He had been the dean at Wake Forest, became the dean of UMKC. And so I'm listening to the lawyer trying to justify what I did based on brain maturity. And Judge Bowman says to the lawyer, well, I don't need no government study to tell me that young people make mistakes. I said, I think I'm in trouble in this case. You know? So I think brain maturity in adolescence is a huge deal. With respect to technology, my experiences mirror that of Judge McConnell. I once was at a judge's meeting and somebody said, can you imagine Abe Lincoln using a PowerPoint to give the Gettysburg Address? I mean, it just doesn't fit.
Doesn't happen.
And yeah, and so I think, you know, it's great when it happens, inventive technology and, you know, putting transcripts up on the screen all in impeachment is great, but, you know, that takes what Nancy just said. You got to listen to the testimony. You can't impeach them without a prior and consistent statement. So,
well, thank you very much to our panelists for sharing their time and expertise.